parole evidence rule has been around for a long time, maybe 100 years, and the exception has been around for probably just as long. And typically the idea is one party has misrepresented something outside the scope of the four corners of the contract. So, for instance, maybe they've misrepresented their financial stability, and the two parties thought it would be a long-term prosperous relationship, and then you invest a lot of time, money, and energy into the project, and then it goes south. And so you get to come into court and say, there was fraud here. We had no idea that these people were in such dire straits. We should be allowed to get out of this contract. And about 75 years ago, the Supreme Court in the Pendergrass decision limited the scope of this fraud exception to the parole evidence rule. And the limitation was this. The party trying to get out of the contract couldn't come into court and say that the terms of the deal were something entirely different than what's in the express provisions. And I think really the idea there was that fraud is about withholding the truth from the other side. And in a case like that, the truth is in black and white. The other side can't be duped or tricked into entering into the contract because the thing that they're saying they didn't know about is actually there. And so now you're going to have this long trial about whether the contract, the deal, was really repayment in 3 months or repayment in 2 years. And from a theoretical perspective, I think the thinking of the Court of Appeal is, well, that's no big deal. You just put some witnesses on the stand and the jury can figure that out. But in the real world, that's just incredibly expensive. It's going to be very difficult to avoid it altogether. The thing that you can do is sort of reduce the other side's ability to come in and make that argument is whatever your most important terms are, you should call out in the contract conspicuously. So you're going to want to put it in bold. You're going to want to put it all in capital letters. You're going to, especially, if it's really, really important, you want the other side to initial that provision. So you're still looking at an expensive proposition, but that's about the best you can do. Make the important terms as conspicuous as possible.